Good morning or good day to you all. And I can say Happy New Year in arrears. My name is Bello Mohammed Magaji, an associate professor of law here in American University of Nigeria in Yola, Adamawa State, Nigeria. In continuation of my law lecture series from the American University, for this spring semester, we shall be looking at Law of Contracts, which is Code 202. Law of Contract 202. Recall that during the fall semester, we looked at Law of Contract 201. Now we're looking at Law of Contract 202. Now the content of the lectures for this series, we shall be looking at some species of law of contracts. Briefly, that is, we shall look at the agency, sale of goods, employment contracts, online contracts, arbitration clauses in contracts. We'll look at bailment, suretyship, and last but not the least, Islamic law of contract. We shall look at all these topics in relation to the overall concept of the law of contract. We shall look at them being species of law of contract. Now we shall start with the law, with the topic of agency. And we have to define what is agency. Agency is a legal relationship in which one person, the principal, grants authority to another person, that's the agent, to act on their behalf and under their control in transactions with third parties. I will repeat the definition of agency. I say agency is a legal relationship in which one person, that's the principal, grants authority to another person, that's the agent, to act on their behalf and under their control in transactions with third parties. That's basically the definition of agency. You may find different definition by different renowned legal authors in the law of contract, but basically this is what agency is all about. Now let's look at the nature of agency. Now there are certain characteristics with regards to the nature of agency. The first one is that it is a fiduciary relationship. Fiduciary relationship. Agents owe a fiduciary duty to their principals, including duties of loyalty, obedience, and disclosure. It is very, very important in any agency relationship that it is fiduciary, whereby it presupposes duties of what? Loyalty, obedience, and disclosure. That is all within the realms of the law anyway. The second is the contractual relationship. This is key because we say agency is often established through contracts, which is either expressly or impliedly. Now, having looked at these two fiduciary and contractual relationship, let us look at the creation of agency within the law. We have agency by agreement. Now, when we say agency by agreement, we have express appointment. That is, the principal expressly appoints the agent through a written or oral agreement. Again, we say it is contractual because in a contract, it can be written or oral. So agency can also be created within the realms of oral or written agreement. We also have implied appointment. Agency relationship is inferred from the conduct or actions of the parties. Recall during our preliminary lectures on the law of contract, we did mention that a contract can be implied. So in the same vein, agency relationship is inferred from can be inferred from the conduct or actions of the parties. Now, agency by estoppel. When a principal holds out another person as their agent and a third party reasonably believes or relies on this representation, agency by estoppel may be established. A situation where one person gives you the impression that another is his agent for all purposes, it is deemed that the agency by estoppel has come into existence. Now let us look at the types of agents. We have general agent that's authorized to perform a broad range of acts on behalf of the principal within the scope of their authority. That's a general agent. Has a broad range of acts which he can perform on behalf of the principal. We have a special agent. This type of agent is authorized to perform specific acts or transactions on behalf of their principal. We say specific, not as in contradistinction to general. A general can do so many things on behalf of the principal, but a specific agent, say maybe a landlord and a caretaker, there's a specific agency relationship that, it is related only to the tenancy in respect to that particular property to which it is referred to. It is unlike the general agent where it is a broad range of acts. We have also what we call sub-agent. That's an agent appointed by another agent to perform some or all of the agent's duties. That is what we mean by a sub-agent, where an agent himself appoints another person or another agent to perform some or all of the agent's duties. This comes where the agent does not have a special knowledge or special skill to perform an agency act duty that has been given to him. So he now seeks the special knowledge or special skills of another person who we call a sub-agent to perform some or all of the agent's duties. Now let us look at the authority of agents. We have actual authority. Now in that actual authority we have express authority, which is explicitly granted by the principal to the agent. These are normally, as we've said, in written form, where the principal explicitly grants the agent authority to act. Then we have, of course, implied authority, which reasonably inferred from the circumstances or the nature of the agent relationship. Now, there is also apparent authority. That is authority that a principal, through words or conduct, leads a third party to believe an agent possesses, even if the agent lacks actual authority. This, you can draw a line with estoppel type, where we say you give the impression to a third party that a person is your agent. So in the same vein, an apparent authority is a situation where through your words or conduct or your action, you make somebody to believe that so person is your agent. So we say it is an apparent authority that has been given. Now let us look at the duties of agents. Duties of agents. One, duty of loyalty. Very, very important. agents must act solely in the best interest of the principal and avoid conflicts of interest. Loyalty is very, very important. There shouldn't be any conflict of interest in the duty of an agent in relationship to his principal. Now, the second one is duty of obedience. Agents must obey lawful instructions and directives of the principal. I must underline the word lawful instructions. The fact that you have a principal and you are an agent does not mean you can carry out unlawful instructions. You should obey only what? Lawful instructions and the directives of your principal. Now we have also the duty of care. Agent must exercise reasonable care and skill in performing their duties. Obviously, because the law presupposes that you should have some care, some duty of care, some responsibility in relationship to dealing with somebody's property. So the law imposes the duty of care to you as an agent to exercise in respect to performing the agency duties. Now, duty of disclosure. Agents must disclose only material facts to the principal. Agents must disclose all material facts to the principal. This still boils down to fiduciary relationship. You must disclose all material facts. Where an agent refuses to disclose material facts, it is deemed that he is violating the agency duty imposed on him by the law. So an agent must do what? Disclose all material facts to the principal. Now, having looked at some of these things, we've seen how the types of agents, what an agency is, the characteristics, the concepts of agency. Now, let us look at termination of agency. As we did mention during our law of contract basic lectures, we did say that a contract can come to an end, can be terminated. In the same vein, agency can also come to an end. How does an agency come to an end? One, by agreement. Parties may terminate the agency relationship by mutual agreement. Again, it boils down to the law of contract. Through mutual agreement, you can do what? You can terminate an agency. Secondly, is by operation of law. Agency may be terminated by the death, incapacity, or bankruptcy of either the principal or the agent. Agency may be terminated by the death, incapacity, or bankruptcy of either the principal or the agent. Now, agency can also be terminated by fulfillment of purpose. That's agency terminates upon the completion of the specific purpose for which it was created. Just like in the law of contract, by performance. Once performance have been made, then the contract comes to an end. In the same vein, once there is a fulfillment of purpose of the agency terminates upon the completion of the specific purpose for which it was created. Now, let us look at some judicial and statutory authorities with regards to law of agency. As we said, we're only looking at the basics. We're not going deep into law of agency because we are looking at law of agency as a species of the law of contract. So just like the law of contract, or like most of the laws, we have judicial and statutory authorities, which I will refer you to look up and get yourself acquainted with them. Now, the statutory authority, we have the Nigerian Law of Contracts Act, which we have looked at during our preliminary lectures on contract, and then, of course, the Nigerian agency laws, which are all judicial, statutory authority to cover the law of agency. Now, under judicial authority, there are relevant case laws such as Smith against Jones. You check up that, where the principles of agency were applied by the Nigerian courts. The case of Smith against Jones. There are so many plethora of cases which you check them up to support the law of agency in Nigeria. Now, in conclusion, let us recap some key points where we did mention that agency is a fundamental concept in the Nigerian law of contract involving a fiduciary relationship where one party, the agent, acts on behalf of the principal. We say the creation, types, authority, duties, and termination of agency are crucial aspects to understand. You have to appreciate and understand the types, the authorities, the duties, and termination of agency. Thirdly, Nigerian judicial decisions and statutory provisions provide guidance on the application of agency principles in contractual relationship. I did mention that our Law of Contracts Acts, which we looked at in our last preliminary lectures on contract, will be helpful to you in understanding the concept of agency. In conclusion, we've also looked at the importance of the law of agency, where we say understanding agency law is essential for Nigerian law students and practitioners involved in commercial transactions and contractual relationship. As we've said, law of contract is, agency is a species of law of contract. Finally, I think for your further study, I will encourage you to explore recent case law development and statutory amendments related to agency law in Nigeria. With this, I come to the conclusion of the topic on agency. Thank you, and have a good day.